Thank you, Commissioner. To get the ball rolling, Mr. Chambers, 6 minutes.
To be here. Nice to see you again, Commissioner. Thank you for attending with members of your team. In 2023, my understanding is that your office released a report that showed in highly regulated sectors, they were more concentrated, they had fewer new entrants, and they had higher profit margins. As a kind of an overlay to this conversation we have today, what would you say is your biggest recommendation on how to deal with that big problem facing Canadians?
Thank you for the question. Thank you, Deputy Chambers, or Member Chambers. Yes, our competitive intensity study was what we released in 2023 that looked at data from 2000 to 2020, and we made all those findings that you referred to. Effectively, we believe the solution in Canada is multi-pronged. We needed amendments to the Competition Act to make it a stronger tool for enforcement. We needed additional resources at the Bureau to catch us up to where we should have been. And both those things have happened in great measure in the last several years with, as you know, several bills before Parliament, and our budget was increased in 2021. The third piece I would refer to as a whole-of-government approach in Canada to addressing competition problems arising from regulations and laws throughout our economy that may unintentionally hinder competition. This is a very big problem in Canada. We rank near the bottom of OECD countries in terms of regulations that hinder competition. And this is something that we've been advocating for some time as part of the solution to what is a very significant competition problem in this country. Hopefully that answers your question.
It does. Thank you very much. Before we get into Interac, I'll just follow up on that last question, or that last point. Would you support then including in the mandates of some of these regulators in highly concentrated sectors or in highly regulated industries that they have a lens of competition on their regulations?
I would go one step further, sir, and recommend that in all areas of the government where policy making, regulation making, rule making, law drafting is done, there should be a competition lens applied to that, and not just the federal government, every government in this country. That is provincial, territorial, municipal, because these regulatory barriers to competition exist throughout our economy. And it is something that, as multiple commentators have said over the years, competition is the elephant in the room in Canada. People haven't paid attention to it, and look where we are.
Well, thank you very much. So let's zoom in now on Interac. My understanding from some information that we've had, and I recognize you may not be able to confirm nor deny it, but that the facts are Interac is currently owned by financial institutions. Therefore, it then sets pricing strategies for the sector, which I understand to be the large incumbents receiving about a 7 times reduction on the price that they pay to send e-transfers, just as an example. I know there's other things Interac does. But that new entrants were paying 7 times the price that the incumbents were paying. Like, on its face, like prima facie, like that sounds highly anti-competitive and a potential abuse of power. And that was what led to the letter to your office. Is that one of the things you're looking at? Like, can you confirm that that's what you're also interested in?
I can't confirm specifics. And as I said in my opening remarks, we've been paying close attention to what's been discussed at this committee with witnesses and with questions and answers. And so we're not aware of the specifics in terms of having seen evidence with respect to the specifics, but those are issues that clearly came to our attention and that caused us to initiate a preliminary investigation.
Okay, well, thank you very much for taking this on. do you have within your powers today the ability to get the information you need to do an investigation or a preliminary investigation to the level that you feel comfortable with?
Yes.
Okay.
Yeah.
And how far back can you go on practices? So if you do find that there was some impropriety, how far back are you able to assess those actions?
Generally speaking, as far back as, speaking generally, not in this particular case, but as far back as the alleged conduct goes.
Okay, so it wouldn't be like a typical statutory limitation period. Look, you can only look at things 3 years ago. The fact that this has been the case for a long time, if there was any finding of guilt, if you will, or some finding, it would be in respect of the entirety of the alleged misuse of power.
Provided the conduct was ongoing to today's date.
Okay. Yeah. Well, look, as I understand, I think I'm just out of time. As I understand, when the pricing schedule was set, the two largest institutions in the company were co-chairing the board at the same time. And one of the challenges we have with this committee and with Canadians is a lack of transparency around the ownership structure of Interac. But I assume we'll get to that later, and I don't want to take time from my colleagues. Thank you, Mr. Chair.
Thank you, MP Chambers. I'll now turn it over to Mr. Turnbull for 6 minutes.
Thanks to Mr. Boswell and team for being here today. Appreciate you joining us. So I have quite a few questions about market concentration or market dominance. How concentrated is the credit card market in your view, Mr. Boswell?
I don't have data on that particular point. I don't know if any of my colleagues have data on that handy.
Is the question about the level of concentration among credit card networks or the issuance of credit cards?
Just the credit card market in general.
So based on a case that we brought challenging conduct by Visa and MasterCard in 2010, we have a finding from the tribunal at that time that that network market is highly concentrated, with both Visa and MasterCard having market power. In terms of the question of the level of concentration for issuing credit cards, that's not something we've specifically studied.
Okay, thanks. And does the Bureau consider Interac's near monopoly in the e-transfer market to hinder competition? And if so, what steps do you think can be taken to encourage new entrants into the market? Mr. Boswell? Or whoever?
I think during your hearings on this issue, you had an acknowledgement from a board member of Interac that I don't know if they used the word dominant, but they were acknowledged that they were the principal player in this space in terms of e-transfers in Canada. In terms of how to enhance competition in the payment space or the transfer space, there are several things that would certainly go a long way to aiding in achieving that objective. The implementation of real-time rail with open access to use the real-time rail system with fair and level pricing would certainly enhance competition in this area, it would appear. The implementation of open banking or a consumer-driven banking framework, I always forget that line, would also allow, facilitate more competition in the banking area generally, and perhaps give fintechs more of a toehold in the payment area. And I think what this committee is doing is the third piece, which is parliamentarians scrutinizing the financial sector for competition issues much more closely and on a regular basis to see what sort of changes could be brought about by you and your colleagues, sir.
Thank you very much for that. And how do you think the exclusivity of Interac's agreements with Canadian banks impact competition from alternative payment platforms? It seems that might exclude them from participating. Is that exclusivity in terms of their agreements with Canadian banks something that concerns you? And how does it impact competition?
I can't speak to the specific agreements. And do you want to add to that?
In terms of the making sure that the membership and the decision making doesn't advantage only certain players and allow incumbents to sort of set the rules that dictate who can join the club, how competition takes place. That is something that we looked at a number of years ago. We had a consent order put in place in the 90s that lasted for a number of years, and that was really looking not only at the governance structure and making sure it couldn't unfairly preference certain members against others, but also conduct that at the time Interac was engaged in that was actively keeping other members out, raising barriers to entry, and really making it maybe more difficult for the members that were there to compete vigorously.
I think it's clear that Interac has a near monopoly in terms of their market position. Does that prevent, it seems to me that it would prevent fintech companies from offering comparable e-transfer services. Have you investigated that at the Bureau at all?
Not at this point in time, that specific sort of fine issue.
But you had mentioned you opened a preliminary investigation on e-transfer companies? So on Interac specifically?
Yes.
And what led to that decision? I realize you might not be able to talk about what the investigate because you're bound by confidentiality, but you might be able to talk about what tipped you off to, initiate an investigation. Can you speak to that?
Quite frankly, as I said earlier, it was hearing some of the question and answers in this committee, and that shed some new light on what might be taking place, and we thought it was appropriate to launch a preliminary investigation.
So is there evidence to date of anti-competitive behavior, Mr. Boswell?
I can't give you that conclusion at this point in time.
Okay. Chair, how am I doing for time? I'm pretty much
You're
over.
just out of
Thank
time,
you.
Mr. Turnbull. Thank you. Monsieur Savard-Tremblay, la parole est à vous pour 6 minutes.
The floor is yours, Mr. Savard-Tremblay. Thank you very much, Mr. Chairperson, and thank you to our witnesses for their opening remarks today. Now, of course, I'll start with a couple of questions, but I'd like to thank you for being here. It's always informative. First, does the Competition Bureau consider that the concentration in the market, electronic transfers for some of the big players, I could list some of them, Interac, Visa, MasterCard. In your opinion, and of course the big banks too, yes or no, does that constrain competition and innovation in any way whatsoever?
Do you want
Merci pour la question. C'est sûr que
Well, thank you very much for the question. Obviously, in a concentrated market, the aim is to ensure that there is more competition. Now, our role at the Bureau is enforcement of the Competition Act, per se. There are two aspects to that. First, ensure that there's no anti-competitive behaviour in the marketplace. And of course, we focus on the concentrated sectors, such as the financial services sector. Moreover, we promote competition with the regulatory agencies and Parliament to ensure that there are rules and regulations that are as pro-competition as possible, with a view to promoting new entrants, competition itself, innovation across all sectors, as well as concentrated sectors. Question. So basically, asking the question is getting your answer. If it's a concentrated sector, it's going to be far more risks in terms of competition and innovation. Both go hand in hand. Have you identified any cases where there are exclusionary practices engaged in, refusing or denying access to payment infrastructures that would have prevented the entrance of new players, such as fintechs, in the electronic transfers marketplace?
tel que mentionné.
Yes. As my colleague Ms. McQuinney mentioned, there is a consent agreement in place with Interac. It was put in place in 1997 and expired in 2020, if I understood correctly. And there were steps under that regulation to counter anti-competitive behaviour in relevant financial sectors. But specifically when it comes to e-transfers, the consent agreement didn't apply to that particular sector. So what was the follow-up to that? What was the upshot? Well, the consent agreement expired in 2020. So, as I said, it applied for that period. There are a number of changes, but as I also mentioned, it didn't apply to e-transfers. Since we're talking about agreements, tacit or explicit agreements between the various and main actors that might constrain or limit access of small players to the e-transfers marketplace, has the Competition Bureau identified any of those?
La mesure où on identifie.
Well, we sometimes identify anti-competitive behaviours, and in those cases we collect details and relevant data. As a law enforcement agency, we work with facts and evidence on that basis, and we encourage stakeholders, if they have any evidence of anti-competitive behaviour between competitors, that they should draw that to our attention. Have you gotten wind specifically of, not just on the part of banks, but financial institutions, including banks, have they exploited their dominant position to put their partners or competitors in a disadvantageous position? Response. Well, as the Commissioner identified, indicated we started a preliminary investigation on the issue, but it's a tad premature to draw any conclusions or findings. Our role is to analyse the facts, the relevant evidence to determine whether or not there's been any possible violation of the Competition Act. But there is an investigation underway. There are hints, there's suspicions, there's whisperings, but you're just confirming the veracity of those. Response. Well, there was a letter from your committee and members and testimony before this committee that led to the opening of a preliminary investigation. How much time do I have left, Mr. Chairperson? 1 minute. Perfect. Does the current legislative framework, is it adequate? I know you're going to say our job is to enforce the legislation, that we shouldn't comment on it, but I'm going to take a stab at it anyway. Is the statute sufficient to properly regulate the electronic payments sector? Well, there have been 3 series of amendments to the Competition Act, substantive ones that have overhauled and updated our legislation. And in cases like these, well, we're going to be implementing those changes first and foremost. But those changes and amendments gave us the tools that we need to better promote competition. Could you tell us what's already been implemented and what will soon be implemented? Almost all of the amendments have been implemented, and royal assent was obtained for Bill C-59 in June of this year, and basically everything has been implemented except for a couple of provisions that will take 1 year before they come into effect, and the same applies to Bill C-56. Royal assent was obtained in December 2023, and if I'm not mistaken, there are a number of amendments that will take effect 1 year later, i.e. December 2024. Question. So you don't recommend at this stage of the game any enhancements to the legislation? You're going to start with these ones that aren't implemented yet. That'll be a starting point, and then you'll see whether things need to be adjusted or tweaked thereafter. Response. Well, we're always thinking about possible amendments to the legislation. and we have some ideas about possible amendments, and we can discuss those with you. But as I said, the amendments that have already been implemented or are being implemented are quite significant, and we're focusing on the implementation. If I have any time left, I'd like a list of those enhancements. No, you've run out of time, Mr. Savard-Tremblay, but I'm sure you'll have more time later on. Plenty of time for more questions. Mr. Massey, the floor is yours for 6 minutes.
Thank you, Mr. Chair, and thank you for our witnesses here today. In fact, actually, Canada had one of the first laws on competition ever enacted in the world. 1889 was when we actually implemented our first law, and then the United States under 1890 with the Sherman Act came in with theirs. And so we've been basically, at least my time in Parliament, outside the box of where we really started as a country in many respects with regards to competition and having some involvement. So I'm glad to see this happening here and the opening of the investigation formally. I've also written your office today as well, too, with Alistair McGregor about frozen potato products, because there's a antitrust suit in the United States that I'm hoping gets some attention, but I'll leave that for the moment. And in one of the things that you mentioned in the first part of your testimony is, are we still missing, I guess, from the perspective of almost like a competition advocacy mandate that is kind of seen stronger in the United States and other places? Is that maybe one of the unfinished pieces of business with our current situation that we have right now? I like the changes that we have. There was others I wanted to see, but is that kind of really what you're getting at with regards to the unfinished business? If those that believe in stronger competition laws and enhancement and oversight policy empowers the Competition Bureau to be able to do more and more in line with the European Union and also the United States, I think is where the hole is that we're missing. If I'm right or wrong, please identify.
Thank you for the question. I think you've hit exactly on what we've been talking about, and we've been talking about it for a few years now, which is that there are the Bureau's job is to address private restraints on competition that are anti-competitive, that are violations of the Competition Act. We are evidence-based. We unearth the evidence. We decide if there's sufficient evidence and take the cases to court or settle out of court, which we have the ability to do. But there's a whole nother basket of restraints on competition that I was speaking with in response to MP Chambers' question, which are public restraints on competition, which are a problem, as I've said, and we've said repeatedly, throughout the economy, all levels of government. We need something akin to what was done in Australia in the 1990s, or the White House Council on Competition that's in place under the current administration in the United States, which is to have a focus or to require governments to think about competition when they're drafting regulations, when they're amending regulations, when they're putting in place new laws. How's this going to impact competition? And that needs to be very deliberate and put in place structurally so that people throughout government at all levels are thinking about these issues. We're not saying this is malicious necessarily, but it has clearly developed into a serious problem in Canada, a lack of awareness of how certain policies impact competition and harm the markets in Canada. So yeah, we're saying this needs to be done, and it needs to be done in a whole of government way because the problems are at all levels.
So it's, to simplify maybe if I could, so it's a more proactive way of dealing with this issue and then ensuring that those that actually want to diversify whatever type of the economy that they're interested in will have, I guess, a little bit better way of advancing their own competitive business models and not being damaged along the way by the current, trying to break through the current model. So our legislative process would be a little bit more proactive as opposed to being right now we're very defensive.
It's more people involved in the decision making, the drafting, would be forced to think about how is this going to impact competition. It's a policy directed at some other issue, but you have to think about, okay, well, how's that going to impact competition in the marketplace? And is there some way of achieving that other goal without impacting negatively competition, without making it harder for people to start businesses, to enter markets, to create more competition, bring more small and medium-sized enterprises fighting for the business, all those issues?
And to our current study here, I'm running out of time, I know, but just to enter a little bit of that discussion, I'll get some more time later. But how do you envision, or can you put some details? Like, I've gone through the rewards programs on credit cards. It is a dog's breakfast. And there's the thought that the rewards process, they like to present it as free, but it actually comes with obligations that might even be corporate secrets amongst the credit card companies and the businesses that they're doing those reward programs for. How do you evaluate or estimate that as you try to figure out, how truly competitive the credit card industry is?
Well, that would involve engaging in a detailed examination of the competition issues at play. What we're talking about in terms of a preliminary investigation, though, is with respect to the Interac fees charged that was raised at this committee. At this point, we're not proposing to engage, for example, in a very broad market study into the entire payment sector or the entire credit cards, payments, and Interac sector. It's a preliminary investigation in response to some of the testimony we heard here at this committee.
Merci beaucoup, Monsieur Massé. Je passerai maintenant la parole.
Thank you, Mr. Massé. Ms. Rempel-Garner, 5 minutes, please.
Response to our letter. In your first round of questions with my colleagues, you mentioned that it was a positive thing that parliamentarians were scrutinizing the financial sector for competition in a broader lens. Are there areas, particularly within the scope of this study related to credit card practices or the financial sector broadly, that you think the committee should be considering?
I'm not sure I'm in a position to give very good advice on the different areas. One thing I should be clear, we don't claim to be experts in the entire payment system. Our focus in our work every single day is competition throughout the Canadian economy. Our act applies to the entire economy.
You have in the past, the Bureau has looked at Interac, credit cards, this isn't the first time Interac has been looked at. So based on that history, are there certain areas now, because we're not experts either, right? Mm-hmm. Are there areas that we should be drawing our attention to based on feedback that the Bureau has received from the public?
Well, I would say that based on our previous Interac consent order, which was from 1996 to 2020, one of the issues there was putting in what we call behavioral safeguards to protect, because Interac was made up of the charter members, which was 8 banks and a credit union, that there needed to be an independent committee that dealt with some of the pricing issues. And I think, and I alluded to this in the opening, paying attention to governance models, which is not necessarily a Bureau thing until anti-competitive conduct results, but paying attention to governance models of these systems, and for example, how the real-time rail will be governed, all those issues.
Committee, that compliance order, is that possible from, and then from there, because I know that the Competition Bureau's mandate in terms of enforcement has changed, were there any enforcement measures that were taken by your agency? I'm guessing not, but with regard to that compliance order that we should be considering?
The compliance order, happy to
Thank you.
provide them. There are multiple different versions
It
of it.
saves me the Google, so
Yeah.
thank you.
It's a lot of reading, though. There's multiple different versions. It changed over the years.
We had a debate about how fast I read last committee, so we're good. Yes, giddy up.
But as my colleague, Ms. McWhinney, pointed out, we do also have experience in the credit card space in terms of the case we brought against Visa and MasterCard for resale price maintenance that revealed some interesting things. We can provide you with that decision. It's quite lengthy.
Okay. Based on, with regard to, our task of coming up with recommendations, particularly with the issue that we wrote to you about, it is within our purview to ask for information from different sources. Is there information that you think would be helpful to parliamentarians in their deliberation of this particular matter?
I think some of the issues that you touched on in previous hearings and information that you indicated you'd like to get I can't think of all the different things, but I know there were multiple when I was reading it that thought that would be very useful for you to have that information in terms of committee structure, decision-making, those sorts of things in terms of this particular issue.
No, that's very helpful. I guess the other thing would be that we have throughout this study bumped up on lack of transparency, particularly in governance matters. In certain federally regulated areas, when you're talking about the need for an overall structure to consider, like let's say at a memorandum to cabinet level, have an analysis on competition. That's a great recommendation. What about like some sort of transparency or requirement for transparency in governance when there is an identified potential abuse of dominance? I'm trying to put the thought together here, but how can, for the future, in areas where there's a potential to abuse dominance, using a lack of transparency in governance, is there a principle in regulation that we could be considering to recommend to the government that could be embedded in that review that would prevent the sort of potential issues that we've seen arise in the course of this study?
I mean, transparency is always of benefit in situations where that tend themselves to be on the edge. And if you can see from the outside exactly how things are structured and exactly how things work in a structural setup that, by its very nature, could lead to problematic outcomes, I think it's very advantageous for everyone to know exactly how the inner machine works.
Thank you for your work, sir.
Thank you very much. Monsieur Gaillir, la parole est à vous pour 5 minutes.
The floor is yours, sir, for 5 minutes, Mr. Gaillir.
Great. Thank you, Chair, and thank you to the Competition Bureau for your testimony today. I wanted to ask, so you said that you have launched or are launching a preliminary investigation. Is it against Interac in general or against Interac e-transfer?
It's to look into, I think the best answer I can give is to look into some of the issues that have been highlighted in this committee and in correspondence we've received and in the motion put in front of Parliament.
Okay, because when they appeared before committee, my questions were mostly regarding e-transfer. As a private individual, I'm pretty happy with e-transfer. They've upped the limit to 10,000. Funds are available immediately when they're transferred. You've got to be careful on the name, number, email that you transfer to. Again, because the funds are immediately available. How familiar are you with the fee structures that Interac uses for e-transfer and otherwise?
I personally am not familiar with them at all, other than what I've heard lately. I mean, I know my own personal situation, my own personal bank account for e-transfers, but writ large, I don't know.
Yeah, so you really are at the preliminary stages. So does the Bureau have any evidence or concerns about Interac's transaction fees being inflated due to a lack of competition?
I think that's to be determined.
Do you know, and again, I understand that this is very preliminary, but do you know how Interac's fee structured? How does it compare with international markets for e-transfer?
I don't know.
You don't know? Okay. You've conducted a study before into Interac. Was that regarding e-transfer or Interac in general? And what were the main findings of that study?
It wasn't a study. Perhaps it's good for everyone to understand just a bit of the history, and hopefully I can do this relatively quickly. So in the 1990s, we alleged that Interac was engaging in exclusionary conduct that restricted access to what's called their inter-member network. More specifically, the inter-member network facilitates, at the time, ATM withdrawals and Interac debit, so point of sale using your debit card. And the three particular things that we alleged Interac was doing: upholding strict eligibility requirements to become a member of the Interac Association. At the time, they favored members of the Canadian Payments Association. They were charging very high access fees to the network and restricting network privileges such as voting rights to charter members only. And the charter members are the large Canadian banks, as well as Caisse et Desjardins, Credit Union Central, and at that time Canada Trust Co. So the Competition Tribunal ordered a consent order in 1996 under the abuse of dominance provision that resulted in opening up the Interac network beyond the charter members and removed barriers to competition between network participants. It prohibited charter members from charging higher access fees to new members and guaranteed non-financial institution representation on the board of Interac. This consent order was varied twice, significantly. It was varied twice, 2013, 2017. And the 2017 version of the consent, what then became called a consent agreement, required the creation of an independent committee of the board to oversee the Interac cash part of their business and the Interac debit part of their business, known as shared services. So we have, as Ms. McWhinney alluded to, the Bureau has had a long involvement up until 2020 with Interac in terms of these consent agreements that require them to do certain things so that we don't get back to the exclusionary conduct that we alleged in 1996, 1995.
Thank you for that. So there's a preliminary investigation. You'll see if an actual investigation is required. We look forward to the findings of that, again, if it's actually required. The question is, if the Bureau were to find anti-competitive behavior in this space, what kind of action could the Bureau take?
Generally speaking, we can take two types of action. We can call for structural reform, which is the sale of part of a business or sale of a whole subsidiary business, or behavioral orders, which is compelling companies that we're dealing with to behave in a certain way going forward, to do certain things so that the anti-competitive conduct doesn't continue. I couldn't speculate right now on that particular issue in this matter, as we're literally just at a preliminary investigation stage.
Great. Thank you so much.
Thank you, MP Gahir. Monsieur Savard-Tremblay, la parole est à vous pour 2 minutes 30.
The floor is yours, 2.5 minutes, Mr. Savard-Tremblay. Thank you very much. Well, in your last remarks, you alluded to a number of recommendations that you'd like to see. Are there any others that you would recommend? Anything else in particular you'd like to add?
Oui, merci pour la question.
Yes, thank you very much for the question. If it's okay, I'll respond in English.
There is recently, in a submission to Finance, Ministry of Finance, called Proposals to Strengthen Canada's Financial Sector, submission by the Bureau in September, we actually recommended the repeal of Section 94B of the Competition Act. Section 94B is a unique statutory override that allows the Minister of Finance to authorize an anti-competitive merger for public interest reasons. This override was established in 1986 and reflects an earlier perspective that anti-competitive mergers may need to be tolerated in the Canadian banking sector for financial stability reasons. But we're of the view that concentration, consolidation could actually intensify systemic risks and raise the cost and complexity of resolution in a crisis if you have increased concentration. We believe that this provision, the Competition Act, unnecessarily subordinates the Bureau's role in reviewing major bank mergers. And there are other avenues that allow the Minister of Finance to review those bank mergers and to allow them to proceed or to prevent them for prudential reasons, for example. So that is a recommendation we hadn't made in the past, but these public interest overrides are very rare internationally, and given the other safeguards that exist in other regulated sectors as well, we don't believe it's necessary to have these public interest overrides on anti-competitive mergers in finance or in transportation. They both exist.
Merci beaucoup, Monsieur Savard-Tremblay. Monsieur Massé, la parole est à vous.
Mr. Massey, the floor is yours.
Just to follow up on that, is there any other country that has this? I know you were touched on it a little bit, but is there anybody left with this type of a policy?
I can't, off the top of my head, think of the examples. They are, as I said, relatively rare in the world to have these public interest overrides for anti-competitive mergers. But I'm sorry, MP Massé, I can't think of the example.
That's okay. We can reach. And you mentioned that as well too at the end of your comments there, transportation. Can you elaborate a little bit on that? I understand what types of the transportation industry are protected that way.
If the Minister of Transport determines that it's that a merger involves a national transportation undertaking, then they can indicate that minister can indicate that they are going to conduct a public interest review of the merger, at which point the Bureau's role, the Commissioner's role, becomes one of providing advice to the Minister of Transportation. First stage of advice is competition concerns with respect to the merger. And then if we provide advice that there are competition concerns, then the parties provide proposed solutions to those concerns, at which point the Bureau the Commissioner is to opine to the Minister of Transport on whether those proposed solutions are adequate to address the competition problems, and then the Minister of Transport makes a recommendation to Cabinet as to whether or not to approve the merger. This has happened multiple times in my time as Commissioner. WestJet Sunwing, we indicated significant competition concerns. It was approved. Air Canada, Air Transat, we indicated significant competition concerns. It was approved in Canada but blocked in Europe. Canadian North, what's the other name? Canadian North and, I'm sorry, I'm drawing a blank on the airline, which was service primarily to far northern parts of Canada. I indicated significant competition concerns. It was approved.
I'd ask our analysts to provide us with that material in terms of the specific amendment required in legislation to cease that policy, please. Thank you, Mr. Chair.
Merci, Monsieur Massé. Monsieur Chambers, la parole est à vous à nouveau pour à peu près 5 minutes.
Mr. Chambers, once again, 5 minutes, please.
When you see a a bad actor or something bad happened on television and the police or the authorities say the perpetrator was known to authorities. In the context of Interac, you have a long and storied relationship with Interac. Would you say they are known, Interac, like you know their business, you know you've had compliance agreements with them in the past, you know about them?
Yes, I think that's fair question. What I can, just to sort of be more precise, our jurisdiction, if we'll call it that, was limited to what I refer to as these two shared services, which was ATM withdrawals and point of sale debit card transactions. So that governed our entire oversight of Interac for 24 years, just those two areas.
Right. But it wouldn't be, this instance is not the first time you've had concerns about Interac's practices, generally.
We alleged it was exclusionary and abuse of dominance in 1995.
In that case, since there's been some previous history, the solutions you may recommend could be more drastic. They're not necessarily a potentially alleged first-time offender in abuse of dominance, at least in respect of previous allegations. Would it be within your authority to recommend to the government that to clean up the governance issues, that the entity be spun out of ownership from the financial institutions themselves?
I don't know off the top of my head. Thank you for the question. I don't know off the top of my head if that would be within the scope of remedies that we could seek. I don't believe so.
The way the abuse of dominance provision works is to seek a remedy, we would either have to make an application to the Competition Tribunal, which is a specialized federal court, or have an agreement on consent with the parties. But there are remedies under the abuse of dominance provision to seek structural relief to remedy competition, but everything flows from the results of an investigation and whether you can conclude that there is an offense.
Okay, I'll just say I would be interested in the Bureau's position on whether, in order to prevent future conflicts of interest, one measure the government might consider would be to free the entity of the conflict of interest with the large owners, the incumbents. You know, you mentioned real-time rail. It's really convenient that we're behind and delayed on real-time rail. And by the way, really convenient that Payments Canada gave a sole source contract to Interac, which is owned by the banks, whose own delays will only ensure their profit pool exists for a little bit longer. So I would say I would welcome the Bureau's recommendations on that front. There's an issue about competition, no doubt. One of the ways that new entrants were trying to accumulate customers was to talk about free e-transfers. And if it is true that the pricing structure was such that these new entrants were significantly harmed with higher prices to offer that service, to me that's a direct decision to limit the competitive landscape by incumbents to prevent entrants from coming in. So that would be one thing I would leave with you. And the final is, on e-transfers themselves, they weren't always free. Many people get free e-transfers today, but they're often paying $1.50. Are you able to look at price gouging from a situation where you know that a financial institution is paying 6 cents for that fee, but then charging someone $1.50 on the other side? Is price gouging something you're able to look at?
Generally, no. We don't look at price gouging. We generally, companies in the Canadian economy are entitled to charge whatever price they want for their products, provided that in doing that they are not engaging in what we call predatory pricing, which is a very different thing than what we're talking about here. It's pricing very, very low to drive competitors out of the market. That's when we talk about predatory pricing.
Thank you. Last question, yes or no. Do you believe one of the CEOs of the banks said there is a ruthless oligopoly and banks are under pressure?
Sorry.
Do you agree that there's a ruthless oligopoly and that the banks are under pricing pressure from within their own ruthless oligopoly?
Krista?
That's what you have to answer.
I was just going to say the term ruthless oligopoly is a bit odd to me.
Yes, saved by the clock. You're out of time, Mr. Chambers. Mr. Area, we like it though.
Between $45 billion and $60 billion, equal to the entire deficit of the federal government. So let's start with that. I'm glad to see Commissioner and his colleagues here. When it comes to competition, I'm in sort of a bit dilemma here. Let's take the example of steel sector where there's open competition, there's no restriction on investment, foreign direct investment. Today, all companies in the steel industries are foreign-owned. The result, there is no increased capacity or manufacturing capacity of steel in Canada for the last 20 years. And they don't export to any market other than the US and Mexico, though we have signed agreements, we have got around 15, 20 free trade agreements across the world. So that is the drawback of having free competition and free ownership by foreign actors. But when it comes to the banking sector, the ruthless oligopoly, where they've been the $50 or $60 billion the profit they're earning, every single dollar comes from hardworking Canadians. And we see what is happening there. But I want to ask a question to you. On Interac or e-transfer, let's take e-transfer for a moment. If I want to transfer $11,000 from my one bank, say CIBC on one end of the street, to say Scotia Bank to the other end of the street, it takes 1 week. Whereas countries in the global south, it can be done in seconds. And, the countries in the global south are still developing, low literacy. We are supposed to be the most developed country amongst the G7 countries. But I don't know whether those sort of things come into play when you look at the banking practices. And do you have the power to compel divestment or the existing owners of Interac to sell the share if you find that there's a deceptive practices there?
Well, I think if under our abuse of dominance provisions, if we were to prove after a case or on consent, but I can't imagine this would happen on consent, if we were to prove after a case, assuming we brought a case, that there had been a significant abuse of dominance, the divestiture is an option, but I can't speculate, certainly at this point in time.
On the question of anti-competitive merger, the power of the minister to use public interest overrides, again, I have got a bit concerned. This concept that we have to move away from the power that is vested with the ministers to use the public interest option to approve a merger, which you deem to be anti-competitive. That was a good case, I think, till a few years back, when we had real free trade, free international trade. Now that the international free trade is dead. Now we are moving towards onshoring, friendshoring, alliances, things like that. So when that is the case, when each country is having its own policy to protect their own industry, I know the negative aspects of protecting the industry, like the banking industry we have here or the telecom industry we have here. But with the changing global scenario, I'm not sure whether we should continue to be the Boy Scout when it comes to competitive practices. I don't know. I'm still in a dilemma. If you can add some comments onto that, that would be great.
Well, I think I was just, thank you for the question. I was raising it in the context of what some of the earlier questions were about concentration in the financial sector, and the resulting, harms that are perceived to take place from that, and just indicated that this was an aspect of our overall legal framework that allowed more concentration, even if it was after a thorough review. The Bureau was of the view that there were significant competition issues with a banking merger. It does allow them to go ahead, and that is a bit of an international outlier. And if we're talking about concerns about competition in our financial sector, then this is something I thought was important to at least bring up for your consideration.
Your recommendations from earlier things that you said suggested amendments to the Act there. And obviously, you always ask for additional resources for the Bureau. That, I think, is a constant. But you also mentioned on the whole of government approach where the regulations are preventing the competitive behavior. Is that what you said?
Effectively, where existing regulations or new regulations, we should undertake the work in this country to examine them. And we could also be aided by all sorts of small, medium-sized enterprises who see these barriers to competition all the time and are aware of them, and they can't get the regulations to change, they can't get the bylaws to change, the provincial laws. They're out there and they can be identified, and we can, undertake the hard work as a country to fix them, to allow more people to compete in the marketplace, to bring their ingenuity, their great Canadian educations, to offer new products and services. It can be done. Australia did it. Australia reviewed 1,800 laws and regulations in the 90s as part of their push on productivity. And as a result of that work, the conservative estimate given in sort of the after-the-fact examination of it, it raised the average income per Australian household in the 90s by 5,000 Australian dollars. That work on enhancing competition in the Australian economy by removing regulatory barriers to competition. And I should say, Australia is very much engaged in doing that again because they realize how important it is for their productivity as a nation to drive GDP growth and to drive to give people more money in their pockets through a more vibrant, competitive economy.
Thank you.
Merci, Monsieur Aria. Je passerai la parole à Monsieur Généreux pour 5
Mr. Généreux, you have 5 minutes. Thank you very much, Mr. Chairperson. Thank you, witnesses. Mr. Boswell, if I understood correctly, Ms. Rempel Garner and my other colleague, whose name I've forgotten, I'm drawing a blank, Mr. Chambers. Now, had they not asked whether there was an investigation being conducted on Interac transactions, we wouldn't even be here today, right? Am I right to say that?
Merci pour la question.
Thank you for the question. If you don't mind, I'll respond in English.
I think what has taken place here is the Competition Bureau pays attention to what's happening at this committee. And in addition to that, we received a letter directly encouraging us to look into the issue. And more often than not, cases at the Bureau, there are many different ways they can begin. But one way is through people coming to us and saying, hey, here's a problem. And we consider those types of issues on a case-by-case basis. And in this case, we looked at the testimony and we decided that it would be appropriate to commence a preliminary investigation.
Quels sont les témoignages qui...
What testimony, in particular, surprised you the most, if I could put it that way, which led you to agreeing to my colleague's request to appear before us? There was a bunch of testimony before you, and Ms. Rempel Garner referred to that testimony. some of which indicated that there wasn't, in fact, we didn't get transparency or not much at all from a lot of witnesses. But what testimony struck you the most? And what testimony gave you the sense that something needed to be done here?
Merci pour la question.
Thank you for the question. I think I'm better off not commenting on the testimony of others in terms of what surprised me the most, given that we are conducting a preliminary investigation. I see, no worries. For the everyday Canadian, and I include myself in that category, we don't have a sense, or when we engage or carry out a banking transaction, whatever transaction that may be, that it's part of a system, and that there's an organisation in Canada, a regulatory organisation, that conducts oversight and supervision. Do you consider your organisation as an oversight body when it comes to competition, or not at all? That's my first question.
Vous pouvez répondre en anglais, ça me dérange.
You can respond in English. Doesn't bother me at all.
I would say we do not consider ourselves an oversight body. We do not consider ourselves as a regulator. We are a law enforcement agency where our responsibility is to investigate allegations of anti-competitive conduct or deceptive marketing. There are many different areas we investigate. And sometimes, sometimes we resolve cases and have in the past with these consent agreements that go on for a long time. And those, we have to take on the responsibility of monitoring compliance with those consent agreements. So in that sense, we do oversee what's happening, but generally speaking, we're not a regulator. We enforce the law.
Dans le cas qui nous concerne, là, vous venez d'ouvrir.
In this particular case, and you've just opened this preliminary investigation, can you estimate the time frame of this investigation? Earlier, you were asked whether or not you are checking back in time and to determine at what point these kinds of practices started. Can you give us a sense of, like, in 6 months, 1 year, 3 years, you'll be able to explain what has occurred and whether to be a conviction or a finding of guilt?
Thanks for the question, MP Généreux. It's very difficult to predict the timeline of an investigation, especially at such an early stage. There are so many variables in terms of what sort of evidence we feel we may need to get, who we may need to get it from, the level of cooperation that we get from parties in the market. There's too many. What I can tell you is that one of the things we're very focused on at the Bureau these days that we believe is very important is moving our investigations faster than we have in the past. And that, that sometimes ties into resources and electronic records and those sorts of things. But I can't give you a timeline, even a guess. I can't even give you a guess.
Considérez-vous avoir tous les pouvoirs pour être...
Do you have the authority you need to get to the bottom of these kinds of issues, in your opinion? In other cases of unfair competition? Do you have the quote-unquote teeth? Do you have the wherewithal? Do you have the power, the authority, the tools that you need to get to the bottom of things, to carry out an investigation, to issue findings and perhaps issue fines?
What I can say in response to that very good question is we're in a much better situation right now than we were 4 years ago in terms of powers to investigate anti-competitive conduct in the Canadian economy. We have more resources than we had 4 years ago. We'd been left to atrophy for a long time in terms of resources, so we're in a much better situation. and the tools we have are to a certain extent streamlined, particularly when it comes to abuse of dominance, so big companies abusing of their dominance in the market. So we are in a much better situation, and we have much better powers than we did a few years ago, sir. Thank you.
Merci, Monsieur Généreux. Monsieur Van Bynen, la parole.
Mr. Van Bynen, the floor is yours for 5 minutes.
Chair, you'd indicated that you're doing a preliminary investigation to see it. Now, if you decide to go forward, does that information come back to this committee, or where does that information go? Where do those recommendations go?
We conduct the substance of our investigations in private. That is, we gather evidence and make decisions along the way if we have sufficient evidence to advance the particular case. And then if we continue to advance it and we believe that there is a problem, that there's evidence to establish the problem, we can either take the case to court, or we can also engage the party who's engaged in the alleged anti-competitive conduct and see if they want to resolve the issue. But our evidentiary findings would not come back here. We do that in private.
Okay. So what I'm getting to is you're reacting to violations, you're reacting to infractions. To what extent are your findings able to inform the regulators?
So one huge component of our work is enforcing the law. Another important area of our work is providing advice to the federal government, federal regulators, provincial governments if they invite us. And we do that very frequently. In fact, by my count, in the last 9 or 10 years, we've made something like 16 different submissions on competition issues in the financial sector. We've made those submissions to the Ministry of Finance, to Payments Canada, I think to the British Columbia government in one instance. One of our recent recommendations was sort of to finance, but about a policy OSFI had. So we have a very active advocacy role in promoting competition by giving advice to regulators. We've given advice to the CRTC many, many times over the last 5 years. So those are kind of our two main lines of work at the Bureau. One is confidential and results in court cases. The other is evidence-based advocacy to regulators.
So you do have access, and can you require a response to your concerns, or is this all just a matter of collaboration?
We cannot require a response.
Okay. What measures is the Bureau considering to ensure the transition to open banking and the digital currencies and how it promotes a level playing field in the market? And one of the things is, yes, I think it's good to have competition. I look south of the 49th parallel, and there's a lot of financial institutions that have collapsed as a result of some of their decisions. So how would you take a look at what's needed to get more competition into the environment, but at the same time, how can we establish the financial stability that's required? And is that your role, or is that your role to advise, so that people don't get into things like cryptocurrencies that disappear overnight?
Well, going back to what I was just saying about our advocacy, we've done a tremendous amount of advocacy to the Ministry of Finance on open banking, on the design, including to Payments Canada on real-time rail. And perhaps Mr. Durocher wants to add to that issue. But I should say, in terms of open banking, we're way behind many countries in this world, way behind, particularly the United Kingdom. And those same concerns about safety, and those were all raised in the United Kingdom and have not come to fruition, as I understand it. So Clearly, there are models out there that Canada can follow while not giving up safety and security. But Mr. Durocher can expand a bit on open banking.
So we've been quite active working with people crafting the open banking regime to try and lend our pro-competitive view. Some critical issues from our perspective are the governance of the system, controlling things like accreditation, who's allowed to access it, some of the technical standards that should be adopted to facilitate competition. So I think, generally speaking, we try and bring our expertise to bear on that specific issue. But on the wider issue about competition versus stability, I would suggest that it's not a zero-sum game. You can have competition increased in the sector without harming stability with effective regulation. And I think that's a very important point in the context of enhancing competition in the Canadian financial services sector.
Is there a plan for the Bureau to set up some regular reviews as some of these new things emerge, or are you solely restricted to complaints and resolving concerns? And if so, what would be the principles or the criteria that you've established in terms of what you would identify as high-risk institutions?
In respect of any regulatory regime, I don't think there'd be a set review by the Competition Bureau. If we're invited to participate in a review process, for example, if there's a public consultation on something being proposed, I think we would participate if we thought we could bring value to the discussion and share our experience. But again, that's just advice that we would provide to regulators as to how to craft a system. But generally speaking, if there's any competitive conduct in a new regulatory regime, or just more generally, it's all about getting the facts and the evidence and reviewing potential infractions. And oftentimes the marketplace or parliamentary committees can be our eyes and ears as to what might warrant investigation. And in a given year, the Competition Bureau receives thousands of complaints, and our role is to triage them and commit our resources to the potential competition infractions that are meritorious and that we investigate them.
Thank you.
Merci, Monsieur Van Bijnen. Je passerai maintenant la parole à Monsieur Savard.
Mr. Savard-Tremblay. Thank you very much. Well, just a parenthesis, if I may, so I understand your role. The investigations you carry out are when there is whistleblowing that occurs, or are you entitled to open up an investigation that doesn't come directly from a complaint per se?
We are. There are many ways we can open an investigation. Thank you for that question. We have a certain element within the Bureau that's dedicated to proactive intelligence, seeing what's going on in the marketplace, where there might be anti-competitive conduct that we should look into. We've in fact created a unit dedicated to providing that type of intelligence. So we can find problems that way. We also are often alerted to problems by players in a particular market, companies in a market that are experiencing what they believe to be anti-competitive conduct. We, as Mr. Durocher said, we get over 5,000 complaints a year that we have to work our way through and prioritize. And there are other examples. There are public hearings that can raise issues or shed light on issues that make us determine that we should look into the issue as well. And of course, another area, very important area, is our relationships with law enforcement in Canada and around the world. We have very tight relationships with competition law enforcers around the world who are seeing problematic conduct that could be going on in multiple different countries where it's a multinational corporation. So there's many different ways we can find out about potential problems.
Merci, Monsieur Savard-Tremblay. À moins que vous ayez une dernière...
Unless you have a final question, I can give you enough, a bit of extra time. Well, if you could just provide a summary of what you just said. It's not just about whistleblowers' complaints. Of your own volition, you can start an investigation. Yes, that's correct. Mr. Massey, the floor is yours.
Thank you, Mr. Chair. With regards back to the Interac time frame, when will that, well, not asking for your time frame, but what would be the, can you disclose the time frame of when there might be consideration of looking at their practices that have taken place? You have a history going back many, many years before. Is it just basically open from that time frame forward? Because you'll be able to use the past issues, I suppose, some grounding. But just wondering, will it, is there a certain point in time that you can publicly say it'll capsulize things, or it's probably too early for that anyways because you don't know where your investigation will lead?
That's exactly right. We're certainly at the early stages, and we do, as I said, we have a fairly long history, so we understand certain aspects. But that particular previous case was confined to the two services that I flagged earlier, which is ATM withdrawals and point of sale debit transactions. So I can't give you a timeline. Apologies.
No, fair enough. Well, I've got you here. Just an issue I flagged with, this is previous to your time, but I think it's a good example of what's taking place is when Live Nation bought Ticketmaster, and we've seen most recently a number of things taking place on that front. Is there anything you can say about that situation and general to the public, or if not, you can just not do that? I'm just curious because I have pushed this issue in the past, and when we have them, basically, you noted a few of the different takeovers that have taken place. The other one is, a famous one was Target taking over Zellers, where Zellers actually had unionized employees paying above the grid and benefits for their employees, and Target coming in and then closing it down, and we're losing that competition. We have Rona by Lowe's and so forth. But any general comments about, as I leave you here, about how do we avoid getting into these situations? Is it really at the end of the day the ministerial level with allowing these things? Every minister changes their opinion and their interest about dealing with these corporate takeovers. Best Buy is another example over Future Shop. I can go on and on, where we've seen the elimination of competition by a minister's opinion at that point in time.
Well, in terms of the Ticketmaster situation, I'm aware of the letter that you sent to Minister Champagne on that particular issue. When it comes to ticket prices, we're not, as we say often, we're not a price regulator. Our job is to enforce the Competition Act, and price gouging and very high prices is something that perhaps the provinces can deal with. Obviously, the Ticketmaster Live Nation merger from 2010 was something that went through the Bureau. At that time, we identified certain competition issues and required certain remedies, including divestitures and some behavioral remedies on that transaction. But in terms of the actual ticket price issue that you flagged in your letter to Minister Champagne, that's really not something within the Bureau's remit.
So that's why I didn't write you on that one, and we've been writing you far too often, I think, anyways. Thank you, Mr. Chair.
Thank you, MP Massey. MP Perkins, the floor is yours.
Thank you, Commissioner and team, for coming on this important study. It's technically on the e-transfer, but I'd like to maybe talk a little more broadly about Interac, but take it one step up. Generally, I believe, Commissioner, that you have a policy that sort of anything more than one company having 30% market share is a problem in terms of at least oligopolistic, if not market dominance. Is that correct?
That's in our abuse guidelines that Ms. McQuinney can speak to.
Yeah, so I'll just step back to say simply being large, dominant under the Competition Act is not a violation. We have certain thresholds for when a dominant entity is engaging in conduct that might violate the Act. We have to also prove that they are in fact dominant, and that's where those market share thresholds come in.
Well, in looking at the market share, like 5 banks to 6 banks, they control essentially 80-90% of the financial services market. And when I sign up for a transaction banking account, am I given a choice of the service providers on things like e-transfer or debit?
I can't answer that because I've never actually looked into it. But I don't know if my colleagues...
I worked for a bank for 5 years. I know what the answer is. It's just, the answer is no. Otherwise, they wouldn't print the Interac logo on your debit card. You don't really get a choice, do you? It comes with an Interac. The Interac market share is massive. I would say it's close to 100% of what Canadians do, whether it's on debit, e-transfer, all of that. And strangely enough, it's the banks that own it. It seems like a convenient way to keep other competitors out by controlling the fact that I, as a banking customer, actually don't get a choice of what service providers and what fees ultimately I would pay for transferring money or using electronic debit. Is that not correct? Like, that's monopolistic power, is it not?
Yeah, so I think that type of thing really would speak to that first part of our test under the abuse of dominance law of whether or not there is market power. And then there's 2 additional big parts of the test that we have to go on and analyze and prove, which is that there's been conduct violating the Act. So that's conduct with an intent to harm either a competitor or competition broadly. And then we have to further look at what the effects in the overall market are and whether there's a substantial lessening or prevention of competition.
Okay, so as a consumer, when I buy my financial services, I have zero choice as to what company I get with my bank account that does that. So to me, that looks like market dominance, especially when Interac is probably 90 to almost 100% of everything that happens. So it's pretty clear it's well above your 30% threshold for Interac. And I guess this will be part of your competition, but we've had evidence that membership has its privilege, so to speak, to quote a former American Express credit card marketing firm. The membership here is the 4 banks and Desjardins that own Interac, that are the board, that govern it, and that get preferential rates because if you're not there, if you're trying to come in as a credit union or trying to come in as somebody who's not part of the membership, the club of Interac as a financial institution, you seem to get charged 7, 8, 9, 10 times the rate for the fees. Surely, if you have 100% market dominance, if the financial services customers have no choice in what service comes with their bank account, and the fees charged for those who aren't part of the Interac club are 10 times what they are to those in, that sure looks like a monopoly power that needs to be broken up.
I think those are exactly the types of things we'd be looking to determine through the investigation and get evidence to establish. Because, normally the Act, as we've been saying, doesn't dictate how an upstream business can charge its downstream customers. But, as you're saying, if that upstream business also competes downstream, has an element of control, then they may well have an anti-competitive incentive to harm downstream rivals, in part by increasing costs.
So if I insist that the company that my retail customer used to process transactions is a company that I own, is that not a monopolistic power? I don't get a consumer choice.
Yeah, so that information would feed into the overall assessment of whether they've got dominance, whether they're doing something deemed anti-competitive under the Competition Act, and then looking at what the overall effects are in the market.
So this examination shouldn't take long when you have 100% market control. Your members have preferential pricing. Your consumers have no choice about what you use. I don't know a bigger monopolistic power than what I see. The banks owning Interac and forcing that as the only choice on the consumers.
Thank you very much, Mr. Perkins. I'll now turn it over to MP Badaway.
I think I'm going to follow in the same line of questioning as Mr. Perkins. And I'll start off with respect to pricing practices. Mr. Boswell, how does the pricing structure of Canada's leading e-transfer providers compare to global benchmarks? Question one. And to that, are fees consistent with competitive market prices and practices?
Thank you for the question. I don't have answers to either of those questions at this point in time.
And Mr. DeRocher or Ms. McWhinney?
No, I don't have that information.
Okay. If I can have that provided, possibly in the future, to the committee, so we can add it into the testimony.
So just to be clear, that's not information that I currently have myself to provide. And when we do collect that type of information, it would be part of an investigation.
Okay, so it's not shareable.
Not until we are in position to publish something about our findings in pursuit of the administration or enforcement of the Act, because that's what dictates what we can share.
That goes for all three of you?
Correct.
Same? Okay. Have there been any instances where fees have been increased in a coordinated manner across different providers?
Sorry, could you? I didn't hear the second half of your question.
Have there been instances where fees have been increased in a coordinated manner across providers?
At this point in time, I don't have any information, and I don't believe my colleagues have information with respect to that in this particular situation.
Okay. In terms of exclusivity and gatekeeping, do any major financial institutions or service providers engage in exclusivity agreements that limit consumer choice for e-transfer services?
At present, once again, I don't have any specific information with respect to that at the current time, other than pointing back once again to our case against Interac, where we had a consent agreement until 2020, where we were trying to address exclusionary conduct by them.
Okay. Any other comments? Or you're all in the same boat? Okay. Are there practices that effectively prevent third-party payment platforms or fintech companies from integrating with existing e-transfer or systems?
I don't.
I think, it's early days on a preliminary investigation. I think these are the types of issues that we would collect the facts and the evidence in respect of. But I would note, just coming back to the notion of the real-time rail, I think open access to a real-time rail highlights the importance of having competitive options to challenge incumbents in any sector. So open banking, open access to real-time rail are very important steps that can be taken to improve the conditions for competition.
With respect to Interac's dominance, Interac is the dominant player in Canada's e-transfer system. I think we've heard a lot about that. Does this dominance pose concerns regarding competition as well as innovation?
So on the law enforcement side, as I was explaining before, being dominant is not a violation of the Competition Act. Even having a monopoly in Canada is not a violation. It's what you do with that. Is the dominant entity doing something to protect itself from having to face competition from its rivals? But I think just to maybe be clear, just because there is not a violation of the Competition Act does not necessarily mean that a market is working well from a competition perspective. I think there's lots of markets where competition can be improved, and especially in a oligopoly type setting where you've got concentration and high barriers to entry. It's sometimes the case that firms competing in that type of market structure don't need to violate the Competition Act in order to reach kind of mutually beneficial outcomes.
And the second part of that question with respect to the dynamics, competitive dynamics, do you find that, or are there current competitive dynamics in the e-transfer ecosystem that are stifled based on innovation as well as development of alternative payment solutions?
So on the law enforcement side, that's exactly the type of thing we'd be seeking to determine in an investigation. But I think my colleague Anthony Durocher has also been talking about certain recommendations we've made to policymakers on the real-time rail and open banking that might be able to better open that up and promote innovation.
Any comment? You're good? Mr. Chair, I think for the most part we've heard a lot from a lot of testimony, but also some we haven't heard yet. And I think going into our future meetings, it would be prudent to invite others that may be able to answer some of those questions. So if you don't mind, I would like to put for unanimous consent a motion on the floor to invite to an upcoming meeting Rogers CEO Tony Stafari. This would be on November 28th, as well as Bell Canada CEO Mirko Burbeck. I'm sorry, I believe Mr. Stafari is coming out already from Rogers?
Yes, he is coming on Thursday.
Okay,
already,
so...
but not on this, of course.
Okay, so I would like to add Bell Canada CEO Mirko Burbeck and TELUS CEO Darren Entwistle to appear and answer questions about allegations of price increases made without consumers' knowledge.
Yeah, so for Bell and TELUS, do I have, I see Mr. Massey. Yeah. I just want to hear from Mr. Massey, given it's his motion to begin with. Brian.
Yeah, thank you, Mr. Chair, and thank you for that. This was originally suggested also by myself earlier, but since that time I've learned that TELUS doesn't do that practice. Bell does. So I'm wondering whether we should just have Bell and Rogers in front of us at that time, as opposed to including TELUS, since they're not part of that practice, from what I understand.
Okay. Well, it depends on MP Badaway if you want to modify your.
No, I'd like to invite those two individuals.
The two, TELUS and Bell.
Yeah.
Just one second, yeah.
So just on point of order, for clarity, Mr. Badaway is asking for unanimous consent to move the motion because there wasn't notice given?
He's asking for, yes, there was no notice given, so he's asking
Okay.
UC to invite Bell and TELUS
to move the motion.
to the meeting that we're having on Thursday with Rogers present.
Precedent, Chair, so.
Yes, but it's given
checking.
It's not a very substantive motion, it's just adding two witnesses to a meeting that we've already agreed to. I'm a bit more loose on procedure, MP Rempel-Garner, but usually I'm a stickler too. Okay, hopefully not. So, MP Massey, I'll recognize you. Just ideally, we could work with UC, but so MP Massey is asking that we don't have TELUS, just Bell. Brian?
Yeah, well, I'm just also wondering what's in order, since I asked for this, and the specific exact thing was denied by the Liberal Party, the parliamentary secretary. So does that create a procedural issue that we inadvertently might find ourselves in? That's what I was wondering as well.
Well, it was decided on by the committee, but the committee can do what it wants with unanimous consent. So that's what's being sought right now. So do I have unanimous consent to invite Bell and TELUS at the next meeting on Thursday the 28th, where we have Rogers? I see no opposition. Perfect. So it is adopted. And colleagues, it's close to 5:15. What I would suggest, given that we don't have time for another full round, is to just open the floor for a few more questions, should members have any, regardless of party affiliation. And when we're done, then we can suspend for a few minutes and then go to our second panel, hopefully before 5:30, so we can end earlier. But on that note, I'll open the floor. I'll recognize Mr. Perkins and then Mr. Gahir.
I'd like to do an informal quick survey. I'd like everyone to reach in their wallet and pull out and look at the back of their card. Does anybody else have any other company on their debit card listed as an option? No. I'd just like to know. Well, that's the same thing. Anybody at the commissioner, anyone in your office, does it say anything?
Don't show your credit card number online, Rick.
You can't see it.
Oh, my God.
It's not a credit card, it's a debit card.
Oh, no, Rick, no. Oh, no.
Let me do my show without interrupting. So nobody has another logo on the back. So to the earlier question or the earlier statement, that looks like an abuse of monopoly power because no one is given a choice. Your card is pre-printed with the company they own as the only option. So is that not the definition of, Ms. McWhinney, what you said earlier about abuse of power?
So I think typically in an exclusionary, if we had allegations of people being excluded from a network or excluded from offering a competing service, that's exactly what we would investigate into. Is there someone seeking to provide a competitive alternative that's being blocked in some way by the dominant entity? That would be the type of conduct that we're looking at under the abuse of dominance provisions in the Competition Act.
Being blocked from another option.
Right. So, but the consumer would need to have a service provider wanting to provide the service.
There are ones trying to get into Canada that have not been allowed in by the system.
And so if there's evidence about them not being able to enter due to conduct that Interac is engaged in, that's exactly the type of thing that would fall within our provisions.
Thank you, Mr.
Thank you, MP Perkins. MP Gahir.
I had a question for Mr. Perkins, actually. Mr. Perkins?
How many shares do you have in this?
He's just... Mr. Perkins? I had a question. Were you talking about credit cards or debit cards?
Debit cards.
Debit cards, okay.
I was holding up a debit card.
Okay. I just wanted to ask about that. So my question to the witnesses is regarding... So you mentioned that you looked at ATMs, right? And ATM withdrawal fees last time you looked at Interac? What came out of that? Because it's still very expensive, right? I think it's like $5 to withdraw any amount from an ATM. Last time I tried to withdraw from an ATM.
It was more the access to Interac's intermember network by other players other than the banks, the charter banks that created Interac in 1984. It wasn't so much about the fees they were charging, but it was exclusionary conduct, letting others join, or the fees they charged them to join the network. Not so much the per transaction fee. That wasn't as an issue back in that case.
Because from recent memory, I think if it's your own bank that you're using the ATM for, at a grocery store, wherever else, you're charged a lower fee. But if it's a different bank from the card that you're using, you're charged a higher fee. So I think that's something that's worth looking into when dealing with Interac. The other question that I had was, and again, I know it's a preliminary study that you're sort of investigation that you're looking at, but Interac, is it for profit? Is it not for profit? And how arm's length is it? Is it at arm's length from the banks? Because they do have a stake within Interac, right?
Yes, correct. My understanding, there's 13 board members on Interac. 8 of them are representatives of the financial institutions that were the founders of Interac. 4 of them are independent directors, and the CEO is also a board member. But Interac is owned by its members, as I understand it, which is made up of the Canada's large banks, as well as Caisse et Desjardins, Credit Union Central, and I don't know what the status is of Canada Trust, but so it's owned by them. And with respect to whether and this is my understanding, just from looking into the issue a bit in advance of coming here, that from our consent agreement, when it was still in place, the independent committee oversaw the ATM withdrawal and debit point of sale aspect of the business exclusively, and that could only be done on a cost recovery basis, so not for profit. But other aspects of Interac, I'm not clear on whether they're cost recovery or for profit or not for profit.
Thank you, MP Gayer. I have MP Rempel-Garner, Savard Tremblay, and then Généreux.
First of all, Chair, I should apologize to my colleague, Mr. Perkins, for being Mama Bear when he I was worried about him, but my worries were unfounded. Nonetheless, I guess
I was personally hoping he would give his card to the
I
chair
know.
for verification.
I know,
Thank you.
right? There we go. Commissioner Boswell, the abuse of dominance provisions are fairly new, right? They've mostly come into place under the most recent provisions of the Competition Act. Is that correct?
They've been in existence, but what happened with the most recent amendments or recent amendments to the Act was they were significantly streamlined. That makes it less complex, if I can use that, for the Bureau to get a prohibition order. That is the court telling a company to stop a certain types of behavior. So yeah, they were streamlined, and that was something that we recommended to the government's consultation on fixing the Competition Act.
Are there any decisions, sort of in retrospect, that the decision that the Bureau took, that particularly in the financial sector, that you think that perhaps as a committee we might want to revisit in light of the streamlining of those provisions?
I can't think of one off the top of my head. I don't know if my colleagues have.
No, nothing specific comes to mind, but we're in the process of doing this work as well, given that we have this kind of significantly strengthened provision to look back at, is there conduct that didn't meet before that might now?
If there's, and I'll close with this, Chair, if there are findings to that effect and you feel that those findings would benefit us in terms of potentially directing our work, would you be willing to table that with the committee, if appropriate?
That's a tricky one to answer because
Understood.
we may decide to do other things if we see a different, if we put the lens of the new law on conduct that's still going on that we didn't take action on before.
Understood. Thank you.
Yeah.
That's all, Chair.
Merci beaucoup. Monsieur Savard-Tremblay.
Oui, je voudrais
Yes. I'd like to pick up where we left off a couple of meetings back. The colleague that I replaced, Mr. Garon, was here, and he gave a demonstration in order to correspond to the access conditions with the reduction of the interchange fees, as MasterCard has done. A restaurant would have to do over 240 services per year, have to sell each of its meals at about $2 or less in the case of MasterCard and $4 approximately in the case of Visa. Have the access conditions in relation to the interchange fees changed? Hasn't that not, in fact, created a barrier to entry for small businesses, or in fact reinforced dominant positions of other businesses?
Je pense on reconnaît que le taux d'interchange.
Well, the interchange rate can have a significant impact on small businesses, and we acknowledge that, and that's why in 2010 the Bureau filed a suit before the tribunal concerning Visa and MasterCard's practices. Now there is a regulatory framework with a code of conduct that's in effect across the industry. Our role is not to oversee the rate itself. It's rather to oversee any anti-competitive behaviour or conduct in the sector. That said, we acknowledge that this is something that's important for small and medium-sized businesses, and that is also why we promote competition in the sector to ensure that the regulatory framework, both current and future, is conducive to new entrants and to innovation. Thank you very much, Mr. Savard-Tremblay. Mr. Généreux, very quickly, and then we'll finish off. I'd like to draw the following to your attention and just follow on to what Mr. Gaillet said earlier. In courts across Quebec, there's cases about the exorbitant costs of withdrawing money, and based on what we've heard, those fees are mandatory. Based on what I've read, I'd just like to draw that to your attention so that you can perhaps check on it. You know, it strikes me that Interac and the bank are saying that it's because of the Quebec government that this is happening. It's as if the Quebec government is imposing this in some way, but that's not true. So I think it might behoove you, as part of your study, to look at these kind of price gouging. The media has categorized it as exorbitant or price gouging in terms of fees. Thank you. That brings to an end our first panel of 2 hours, and I'd like to once again thank Mr. Boswell, Commissioner, with Mr. Durocher and Ms. McQueenie. Thank you for coming before us. I'll just suspend very briefly so that we can have the next panel, the Financial Consumer